I want to thank everybody for being here tonight. We're going to discuss a little bit about Senate Bill 732. I guess I should start by thanking Professors Uphoff and Litton and Josh Kezer. For those that don't know, Josh is a exoneree, and the professors and Josh will have a panel here after I give a couple of little remarks. I think the best way to start would be let's talk about the bill first. The bill essentially does three things. It identifies improvements in eyewitness identification procedures, custodial interrogation procedures, and biological evidence procedures. We spent a lot of time last year and this year trying to hammer, get a consensus on most of this. Sometimes you do, sometimes you don't. So it's still a work in process. But I think it's important that we have the discussion, and that as we move forward, we may not get everything that we want this year, but we can continue to work on this and try to avoid some of these unfortunate mistakes that we make. So, I think to start, I think we want to do a little video on eyewitness blind administration. This was on the NBC News. I think you'll find this pretty telling. Go ahead.
Nationwide, 75% of prisoners exonerated by DNA evidence were originally convicted on the basis of faulty eyewitness identifications. And no jurisdiction has released more people on that basis than Dallas, Texas. In 2009, the police department there decided to change the way it did lineups.
One innocent person serving time in jail is unacceptable, period.
David Brown is chief of the Dallas police.
We broke everything down and just started from scratch.
They looked at everything, from what can go wrong when witnesses view the usual suspects all together, like you see in the movies, to whether detectives were unconsciously tipping off witnesses as to which photo to choose.
Once we figured out what the science was telling us, we built our practice around the science.
This is the new way lineups are done by the Dallas PD, one of the few departments in the country to videotape the process. This woman is trying to pick out a suspect in a homicide case.
I'm a photo lineup administrator, and my job is to show photo lineups.
Lineups are now administered by an officer who knows nothing about the case and who doesn't know which photo is the suspect.
No.
Also new, the officer explains the suspect may not be in the lineup at all, and that the investigation will proceed whether or not there's an ID.
You can pick it up.
And as you can see, the photos are now shown one at a time. But could you see departments someday following what might be called someday the Dallas model?
I believe so. I'm really confident that this will end up being the model, the practice for the country.
That kind of takes your breath away a little bit. So, again, the whole goal is to make sure that the eyewitness identifications are unbiased, that the victim or the witness isn't steered or pointed in any kind of direction. Just something blanket like that where she can see, the person that she believes was the perpetrator. So with that, what else is on the bill? The bill does, I talked a little bit about it. The key provisions requires law enforcement to have written procedures regarding eyewitness identification and a biannual review of that. Court considerations considering the identification of evidence that does not comply with the procedures. On the custodial interrogations, repeals exceptions regarding suspect requests not to record it. Basically, all the custodial interrogations have to be recorded unless it falls under one of the exceptions that we have. And in Missouri, we have a lot of exceptions for that. And biological evidence, it just determines how long the evidence is maintained. And you all have it here on this handout. This is a pretty handy little deal. And with that, I got one more video. This is kind of a game. This kind of talks about the reliability of eyewitness identification.
This is a test of selective attention. Count how many times the players wearing white pass the basketball. How many passes did you count? The correct answer is 15 passes. But did you see the gorilla?
So anyway, I'm going to turn it over to the professors here, and thank you very much.
Thanks, Senator. My name is Rod Uphoff. I teach at the University of Missouri Law School with my colleague Paul Litton. I actually teach a course called Wrongful Convictions every fall, and that's a course where I spend the entire semester talking about what we're going to talk about in the next half an hour. So we're trying to condense a lot of material into a really short period of time. We hope you find it useful, because what my class does is spend that semester trying to figure out why it is the criminal justice system doesn't get it right more often, and why it is that unfortunately we produce wrongful convictions more often than we wish. And then we analyze how we might restructure or reform the system to get it right more often. The good news for all of you is, unlike my students, there isn't going to be any exam at the end of this session. So that's the good news. The other news is this isn't a lecture. If at any point you have any questions, you want us to clarify anything, just raise your hand and I'll try to address your concerns. First thing that the senator asked me to pay attention to is, how big a problem is it? Is this a problem that only happens once in a blue moon, or it's incredibly rare? Does the system really get it right? As some suggest, the system gets it right 99.9% of the time, so wrongful convictions are not something that we really need to turn our attention to. There's a couple things that I'd like to point to that I think demonstrate the problem is much more serious than some defenders of the system would suggest. And one of the first slides that I'd like to talk about is a study that took place run by the FBI and the National Institute of Justice for the first 10,000 DNA cases. Prior to 1989, there really wasn't DNA used very often in this country. From 1989 to 1996, police departments around the country sent evidence to the FBI to have it analyzed. And in the first 10,000 cases that they analyzed over this period of time, 60% of the time, the eyewitness identification, which had led the police to either arrest and or charge the person with the crime, 60% of the time, the eyewitness identification testimony had been accurate, and the person that had been arrested was in fact confirmed by the DNA evidence. In roughly 20% of the cases, there wasn't enough DNA evidence to result in a conclusive identification. In slightly over 20%, almost 23% of the cases, the arrest was wrong, that the DNA excluded the person as the perpetrator of the offense. Those findings have been consistent since that initial study, which ought to suggest to us and ought to raise some serious concerns. Why? Because in over 90% of the cases, we have no DNA evidence at all. we have to rely on eyewitness identification testimony, and unfortunately, like this study, other studies in the laboratories, other research shows, as the Supreme Court has said, eyewitness identification testimony is necessarily fraught with the possibility of being wrong, and is wrong in a number of cases. Unfortunately, we have no way of knowing, absent DNA, when that eyewitness identification testimony is accurate and when it is not. One of the most chilling examples of this that I saw was when I listened to Jennifer Thompson, who there's a famous case called the Ronald Cotton case. Jennifer Thompson was a young North Carolina co-ed who was raped by a man. She had almost an hour to study that man's face and all the features of that man. And as I heard her when she spoke at this conference, she said, I wanted to study everything about this man so that if I lived, I'd be able to pick him out and I'd be able to make sure that he got the justice he deserved. She identified a man, Ronald Cotton. And the police chief who also spoke at this conference said, of all the police cases he was involved in, all the criminal cases he was involved in, he was never more convinced of the reliability of that identification than of Jennifer Thompson's. Unfortunately, Jennifer Thompson was wrong. Another woman who also picked out Ronald Cotton was also wrong. Ronald Cotton spent 10 years in prison for a crime he didn't commit until DNA subsequently identified the real perpetrator. So why am I convinced? That FBI study, there was a study done in 2012, a DNA study of hundreds of thousands of cases in Virginia. Unfortunately, of those hundreds of thousands of cases, they got less than 1,000 cases where they had DNA that could still be tested. This was evidence that wasn't tested during the 70s and 80s, but they still had physical evidence that could be tested. When they tested, and these were all convicted defendants, when they tested that DNA, the results showed at least 8% of the cases the convicted offender could be eliminated, 5%, but there was still other evidence which could, not necessarily definitively show that he was the perpetrator, but other evidence, so they didn't consider him as in the 5% group. 5% of the time, the person should have been eliminated and never convicted. So if somebody's telling you that 99% of the time the system's getting it right, there is just no research around the country that corroborates that figure. No one can tell for sure how many times the system gets it wrong. Why is that? Because it varies from jurisdiction to jurisdiction, but 95 to 97% of the time in jurisdictions around the country, convictions are not the product of a trial, they're a product of a guilty plea. And researchers around the country have come to the same conclusion that I have. There are a number, and no one knows how many, but every criminal defense lawyer who's ever practiced knows, and everyone who's written on the criminal justice system knows, including Justice Scalia has acknowledged this now, that innocent people will plead guilty when confronted with going to trial and facing a 20 to 30 to 40 year sentence and sometimes even the death penalty. And their criminal defense lawyer says, I don't think we're going to win. So here's your choice. We can go to trial, and if you lose, you might get the death penalty, or you're going to get a 30 or 40 year sentence, or you can plead guilty because they're offering you 3 years in prison. And it is entirely rational for an innocent person under those circumstances to say, I'm not going to take the risk. They particularly don't take the risk when their defense lawyer has not done his or her job. And unfortunately, one of the leading causes of wrongful convictions is bad criminal defense lawyering. Wish that I could say in the great state of Missouri that we have every one of our defendants gets represented by a quality defense lawyer who's going to do the job that our Constitution demands of them. Unfortunately, that's not the case. We unfortunately have a very underfunded criminal defense public defender system, and there are plenty of examples of failures by those criminal defense lawyers to do the job that all of us would want if we were a defendant or any of our family members were defendant. So that's one of the leading causes. This bill doesn't have anything to do with the public defender's office. It doesn't address that aspect of wrongful convictions. But there are 6 leading causes of wrongful convictions. And everyone writing about criminal justice system and writing about the problems of criminal justice system focuses on those 6 causes. We're not talking about one of the 6, and that's ineffective assistance by a criminal defense lawyer. We're not talking about prosecutorial misconduct or prosecutorial error. That's another cause. Not in all cases, certainly, but it's a cause in some. We're not talking about over-reliance on snitch testimony, although that's another area that's a problem. We're talking about 3 areas in this bill: eyewitness identification, testimony, false confessions, and we're talking about forensic issues. Eyewitness identification testimony is far and away the most important. 75% of the DNA exonerations involve mistakes made by eyewitnesses who were trying to get it right, who were not purposefully fingering the wrong person. They were, like Jennifer Thompson, trying to do the best job, but there were mistakes made oftentimes, not always, but oftentimes during the identification procedures. And what this bill tries to do is what a number of other states, and Paul's going to talk about a number of other states who have adopted similar procedures to try to make sure that we do a better job eliminating the suggestive procedures that sometimes lead to the wrong person being picked out.
Before we talk in some more detail about the eyewitness identification procedures, let me just mention that this is not just an issue that's important for treating the innocent properly, right? It's not just a justice issue about the innocent. It's also, in our opinion, a public safety issue. Because the studies showed that in 48% of the DNA exoneration cases, the real perpetrator was later identified through DNA evidence, and in 48% of the cases where the real perp was identified, in 48% of those cases, the real perp committed more violent crimes while the innocent person sat in prison. And therefore, while the innocent person is sitting there in prison, the police investigation is done, and the guilty person is out there in many, many cases committing more crimes. Before we talk a little bit in more detail about the eyewitness identification procedures, I want you all to witness a crime. So I'm going to play a quick video. I want you to witness the crime, and I'm going to show you the lineup, and I want you to pick out the suspect. And then we'll talk a little bit more about the
perpetrator.
Yeah, sorry, that's right. Pick out the perpetrator.
This is a good one.
So how many people think it's number 1? Raise your hand. If you remember number 1. How many people think it's number 2? Raise your hand. How many people think it's number 3? Raise your hand. How many people think it's number 4? Raise your hand. How many people number 5? Raise your hand. And how many people think it's number 6? Raise your hand. Okay.
Unfortunately.
What's the correct answer, Professor Litton?
Unfortunately, we're all wrong. You're all wrong who raised your hand. The suspect was not in the lineup. And so this shows two things. One, often police don't tell the witness that the suspect might not be in the lineup, but it's very important to tell the suspect that to tell the witness that the suspect might not be in the lineup. And that's just one of the things that the bill recommends, that the police, the procedures should, one of the things that the police should do is tell the eyewitness the suspect might not be in the lineup. That's one of the recommendations in the bill. It also tells us one other thing about eyewitness identifications, which is that what eyewitnesses do is they pick out the person who looks most like their memory. So that's most likely what you did. You probably picked out the person who looked most like your memory of the suspect. However, that's the problem. When you see an array of people in a lineup or an array of photographs, eyewitnesses tend to pick out the one who looks most like, even if it's not a perfect match of their memory. And that's how mistaken identifications occur.
The challenge, I think, for the system, and the challenge that my students are involved in over the course of the semester, and the challenge that's faced other jurisdictions as they've tried to deal with the problem of wrongful convictions is, how do we make changes that are going to minimize the conviction of the innocent without decreasing our ability to hold those who commit crimes accountable for their crimes? Because public safety, as Paul is suggesting, public safety is not promoted if we are releasing guilty people, nor is it promoted if we are convicting the innocent. Paul suggested that some of the statistics of the people who have studied the cases of these exonerees is that 49% have the real perpetrator went out and committed new offenses. In Illinois, for example, not only did they look at the 14 murders, 11 sexual assaults, 10 kidnappings, and 62 other felonies committed by Illinois perpetrators who were not gone after because they had arrested the wrong person, but a Chicago Sun-Times article indicated that Illinois taxpayers paid $214 million. That's only in damages to people who are wrongfully convicted. It doesn't factor in all the other costs to the family and to others suffered if the system gets it wrong. So I think we can do a better job, and I think there are ways of doing a better job, and that's part of the reason why we're here today to talk about aspects of the bill. When I mentioned earlier that 25, or that I thought that there was a considerable number of people, and by considerable, I don't know if it's 5%, 10%, I don't know what that percentage is, but I'm very confident that there are people who plead guilty despite the fact that they're innocent. Of these DNA exonerations, 25% involve people who either falsely confessed, and when we say falsely confessed, we mean the police said they confessed, or they said they confessed, but said the only reason they did it is because of the pressure during the interrogation, and they wanted to get out of that room, and they'd say anything to get out of that room, or they pled guilty. And in some cases, like Chris Ochoa, and I think we should play a short tape from Chris Ochoa. I've met Chris. Chris was a young man in Dallas, Texas, who had never been in any trouble before, who was working at a restaurant when one of his co-employees was murdered. Chris and his co-employee somehow the police figured that they were suspects, and here's the clip.
In 1988, I was accused of a crime, convicted in 1990, I believe, of a murder and a rape that I didn't commit. Served 12 years in a Texas prison on a life sentence before I was exonerated through DNA evidence and through the real perpetrators, the real murderers' confession. When I was first brought in for questioning by the Boston Police Department on this murder and rape, they told me they came up to the Pizza Hut and they said they want to talk to me about burglary. And I said, sure. And I went with them, and they drove me to the police station, and when they were driving me, I had never been in prison before, or in trouble, or any kind of trouble. I've been with Mr. Straight A. I was brought up to, trust the police officers over there to protect me, over there not to hurt me. So I answered the questions as much as I could, well, what I knew, but I knew nothing about this murder and rape. But they took it as a sign that I was covering up something, and they kept on saying that I had something to do with it, I'm just lying, I'm not being truthful. And this went on and on for like several hours, and then this came with threats that if I didn't cooperate, I didn't tell them the truth, I was going to go to death row because it was a capital murder, and I was going to die on death row. And ultimately, after many hours of interrogation and threats, I just was wore down, and I told them what they wanted to hear.
And the interesting thing about Chris, and I've met Chris, I met him because after spending 10 years in prison, DNA ended up confirming that he had nothing to do with the rape murder, nor did his co-defendant. Unfortunately, his co-defendant was beaten and suffered brain damage while he was wrongly incarcerated in prison as a result of Ochoa's testimony. What Ochoa said was, I eventually told the police what they wanted to hear because I was confident that once I got a lawyer, the lawyer would help me straighten it all out because I knew I was innocent. I knew I would never have to go to prison for this. Unfortunately, the police only took some of his confession and videotaped it, didn't videotape the parts where he was getting the facts of the story completely wrong. That part of the videotape was destroyed and not made available, so his lawyer is left with a videotape where he confesses and he names his friend, and his lawyer tells him, they're offering us life imprisonment. If you go to trial, I think we're going to lose at trial and you're going to get the death penalty. And his mom told him, do what the lawyer says. The lawyer says just plead guilty, and he did, and spent 10 years in prison. Now you might be saying, well, this is just an isolated example, and this kid obviously wasn't very smart. This kid was smart enough that after he got out of prison, he went to the University of Wisconsin Law School, graduated from law school, and now is a successful lawyer. I've got an article from the New York Times involving a young man out of Kansas City who pled guilty to a rape that he didn't commit, and it's eerily similar. What he says was, eventually I knew I wasn't guilty of this rape. I just told the police what they wanted to hear because they thought I was guilty. I figured when I'd get a lawyer, it all got straightened out. It doesn't work that easily.
And just to add, the bill in requiring the recording of interrogations and attaching some consequences to failures to record interrogations, at least in our opinion, it's not a pro-prosecution or a pro-defense or anti-prosecution or anti-defense measure. It can benefit both sides, right? A defendant can't say, I was coerced when it's been recorded, and you can see the defendant voluntarily waiving his Miranda rights and signing a confession right. So this is not pro-defense, it's not pro-prosecution. It's just we're trying to get things right.
In fact, in most jurisdictions across the United States that have implemented this kind of legislation, the police and prosecutors at the end of the day are very happy with this legislation, because taping in the vast majority of cases cuts in their favor. Tom Sullivan will, I think, come and testify, former U.S. attorney, will come and testify at the hearing in this bill, and he will tell you he's worked with police departments all across the country, and they are very much in favor of taping. One of my law students who was in my class this last semester was a Columbia police officer. He taped, and he will tell you that that taping worked to his advantage in a host of cases where the defendant made allegations about his conduct, and in every case the taping backed up what he said. For good police officers, they have nothing to fear about taping. It's going to work to their advantage. It's going to work to the prosecutor's advantage. In a limited number of cases where the police are not doing it the right way, then that's not the kind of case that we want to be supportive of, because those are the kind of cases that oftentimes end up in wrongful convictions. You want to watch a great documentary. We're not going to show it here tonight. It was nominated for an Academy Award. It's called Murder on a Sunday Morning. It's an actual case out of Jacksonville, Florida, which highlights the fallibility of eyewitness identification testimony. A young 15-year-old guy was pulled, a young black kid was pulled out. He had happened to be walking past the scene of a murder. A tourist had just been shot and killed. Her husband was right there. He saw the shooter from this far away, and he said, as they brought this kid in a very suggestive show-up, "Is this the guy?" And of course the guy's in handcuffs. And that very suggestive show-up led the person to say, "Yes, I'm sure that's the guy." They then took the guy down to the station. Ultimately, they coerced a confession from this 15-year-old kid. He was tried for murder. And what's great about this particular documentary is, but for the work of a very good criminal defense lawyer, that would have been a wrongful conviction. That criminal defense lawyer, you can watch, it's about an hour-and-a-half documentary, you can see what a good job he did. The system worked, except after the fact, the Jacksonville Police and Prosecutor's Office said, this is a case of an injustice. The only reason this kid got off is because he had a slick criminal defense lawyer. That could have been the end of the story. Was it an injustice? Did he get off because of a slick criminal defense lawyer? Or was this a potentially wrongful conviction that was averted because of the work of a good criminal defense lawyer? 6 months or 9 months later, the public defender gets a tip from one of his clients saying, there's a guy in the cell, and the guy in the cell is bragging that he was the one who did the tourist murder. This public defender went to the police and said, reported this tip. There was a police officer there who checked in their evidence locker, and in their evidence locker they had a purse from the dead woman that the police did not bother to test. Why did they need to test? They had an eyewitness and a confession. When they tested it, it matched up and showed that the guy in the cell who was now bragging about the murder was the actual murderer. So justice was done in that case. It's a fascinating case. As I said, it was nominated for an Academy Award. It's worth seeing.
We're going to just do one more quick exercise, just to emphasize once again the fallibility of our memories. And this exercise is this is Jennifer Dysart. She is a psychology professor at John Jay School for Criminal Justice in New York, and she's going to talk just very briefly about composite sketches, and the effect of composite sketches then on later recall.
So what I want you to do is just visually scan these sketches, compare the sketches as I'm telling you the story of how these came about. These are from a case, and actually 9 different cases in California. where these are sexual assault cases. So these are all from rape victims. And it was a big practice in this police department to do sketches and composites. In fact, there were a few other victims who said that they just didn't get a good enough look in order to be able to do the sketch. So these are victims who had a good enough look to be able to do a sketch. Fast forward a number of years, so you can see that these are mostly 2000 to 2002, and DNA testing was done on all of these rape kits. And guess what? It's the same guy. So, let's see, he wore a hat or covered his hair in some way each and every time. But as you can see, there are, if you look at the dates, teardrop tattoos that are on and off, one side or the other, change in number, just as one example. But the individual looks to be of different racial and ethnic backgrounds from, if you were to pick, kind of two sketches. And so the real question here is, and look at the age, the top to the right, the age looks 20 years different. So the question has to remain, if the eyewitness creates one of these and then has this, sometimes witnesses are given a copy to take home with them. The issue about contamination of the witness's memory is their memory of the perpetrator what he actually looked like, or is it now closer to what the sketch is that they created? So it's not really a surprise if someone sees a sketch, right, says, oh, I think I know who that is, and then the witness picks a person who happens to look very similar to the sketch. Right? We shouldn't be surprised that ultimately happens.
So, just again, part of the purpose of the recommendations in this bill is to make sure that memories aren't contaminated, right? That's part of the point here. Not only was one of Professor Dysart's points that our memories aren't great, but that then things that happen after the event can actually contaminate our memories, right? Like being handed the sketch or having a police officer say to you after you've identified somebody inadvertently, not invidiously at all, just, oh, good job, you've got that's the person. Because just saying that can increase the person's confidence level, which then affects their testimony at trial. So many of the measures or suggestions in this bill are just to prevent that sort of contamination of memory. But I'm just going to say one last thing before we wrap up, and I just want to say that if in taking up this bill, Missouri would not be taking some sort of radical lead around the country. States are already passing this kind of reform. Georgia is one of those states. In terms of eyewitness identification reform, you'll see, again, we're not just talking about this is not a liberal or a conservative issue. You can see the states, some of the states that have passed this sort of reform: Texas, Georgia, North Carolina's bill is the most comprehensive. Connecticut, New Jersey. Also, some cities have taken it upon themselves to pass these kinds of eyewitness identification reforms that are suggested in this bill. So again, this is not us taking some sort of radical lead. In terms of having a statute that requires the police to record interrogations with, also, you'll see there are states around the country from Indiana and Illinois, Alaska, Nebraska, North Carolina, that have provisions in their bills that are pretty much exactly like the ones in Senator Keaveny's bill. So again, we're not reinventing the wheel here.
Last point I'd like to make, and then Josh is going to talk. We haven't talked much about preservation of evidence, but what everybody, I think, agrees upon is we're only getting DNA in 10% of our cases right now. The more DNA we can collect, the world unfortunately doesn't function like CSI. Wish that we had all of the magic crime-fighting tools they have on CSI. That's television. In the real world, we get less than 10%. We need to, and if I had to invest money in the criminal justice system, the money I would invest would be to minimize as much as we could the reliance on eyewitness identification testimony and try to beef up our ability to collect, preserve, and properly analyze DNA evidence. The better job we can do in collecting, preserving, and utilizing that evidence, the more likely we'll be at getting the bad guys and successfully prosecuting them and minimizing wrongful convictions. So that's an important thing that I think all of us, again, this is not a partisan issue at all. This is an issue where we can be better as a system if we do a better job collecting, preserving, and analyzing that evidence. And that's all we have. We're going to turn it over to Josh.
Angela Michelle Lawless. That's why I'm here. Some of you may know that name, and you may know why I mentioned that name. Others of you probably don't. That's the victim in my case. She's my motivation for doing events of this nature. Victims, in general, widely, are my motivation for doing events of this nature. I personally am not interested in recalling my trauma before a group of people and putting myself through that memory time and time and time and time again for my own benefit. I have a better time personally sitting at a beach somewhere not thinking about this. But the victims in these cases, they need us to get this right. We're victim advocates here. Ultimately, that's what I am. I believe that's what these gentlemen are. I believe that's what everybody is that supports and promotes a bill of this nature. They did very well in presenting to you a how we can change these things. That's the science. It's the how to change these things. I'd like to talk to you about why. And rather than introduce myself as Joshua Charles Kezer, perhaps I should introduce myself as Exhibit A, since we're talking about criminal cases. Now, I'd like to ask each one of you, think for a second. I'd like for you to look at this picture. And I'd like to, for a moment, what do you notice in this picture? Can I get a couple of people, not you guys, can I get a couple of people to tell me what you notice in this picture, first thing? Anybody? What's different? Show the next picture. What's different now between that picture and the picture you just saw? Huh? I was young, that's one thing. Anything else?
The scene.
Huh?
The scene.
The scene? Scenery behind me? That's one thing. Anything else? Good idea. Anything else?
Red shirt.
A shirt? Okay, we'll take those. My man.
Well, it does identify you as a suspect with the police department logo or signature on there.
Police Department, Bourbonnais, Illinois, right across my chest, with numbers down the side. That is obviously a mugshot. That picture was presented in a lineup to people to identify me. And judges ruled that it was a violation of my rights. It influenced the decision. Now you can go ahead and continue to roll the other pictures. Now, I got these pictures showing because I wanted to see the progression of age here. So you can see I was once actually a child. I wasn't born 38 years old. I was a little kid. There's a progression of time here. Now, I want to get to the identification. In my case, there are varying aspects of innocence that I can discuss, but I am here to talk about eyewitness testimony. In my case, I want to talk about three specific groups of people: Mark Abbott, Chantel Kreider, and people that attended the funeral of the victim. In Mark Abbott's case, he claims to have seen somebody at the scene. He claims to have seen a person at the scene. Now, strangely enough, Mr. Abbott is now the primary suspect in the case now that I'm free. He initially said I was a light-skinned black man. Am I light-skinned black? No. I checked. He also said I managed to also be a carload of Mexicans. I don't resemble a carload of anything. And then he settled on a pale white kid from northern Illinois. And how did he do that? He did that with the mugshot that was showed to him. And while he was being shown the mugshot, off the record, some of the cops that were present stated he was given hints. Now, Chantel Kreider. No, really quick. No, I'll go with Chantel. Chantel Kreider. She's sitting in the trial. She's one of the victim's best friends while the victim was alive. She's seen in the trial. The prosecution's not winning. The prosecution hasn't presented any evidence. Fingerprint, palm print, DNA, motive. There's nothing. I had an alibi that put me 350 miles away from the scene of the crime. The DNA that was presented, the blood found underneath the victim's fingernails at the scene of the crime was tested by the FBI. And they excluded me. She's sitting in the trial, she's seeing what's happening, and she's getting confused because the sheriff and the prosecutor had told her that I had done this. And see, Chantel got confused, so she, depending on what story you believe that she told, she made up a story. And she said that she saw me get into an argument with the victim at a Halloween party. There's your motive. She got on the stand and testified against me. Despite the fact that there was a police report that in fact had documented that event of Michelle getting into an argument with a gentleman and had named him, and it wasn't me. The judge wouldn't allow it. If anybody can explain that one to me, to this day that baffles me. Chantel Kreider, years later, in 2008, got on the stand here in Jefferson City and wept. She cried. She apologized to me in open court. She said that she was coached into saying it was me. That the people that she went to and said, well, I think maybe I saw him with Michelle, had pushed her in that direction, according to Chantel Kreider. So her intention wasn't like Mark Abbott's, who is now the primary suspect. Mark Abbott's intention was to lie, to distract. Mark Abbott's, his intention was to get people to pay attention to anybody else other than himself. Chantel was confused, but the results were the same. And then you have the people that are at the funeral. There were a half a dozen people that attended Michelle's funeral that were willing to testify they saw me at the funeral. Well-intentioned people. I believe these people probably love Michelle, love the family, grieved, seeing her family fall apart, eventually end in divorce, and they wanted to help. They wanted to do something. Thank God my attorney was able to produce records while I was at work that day. The Wendy's organization, they produced records. I was at work, I had a time card 350 miles away. It was impossible for me to have been there at that funeral. But people were willing to testify to that, and would have had that record not come out. They didn't testify at my trial. So we have lie and distraction, we have confusion, and we have well-intention, but they all produce the same result. They were identifying the wrong man. One misidentified several races, another one I misidentified through tears and anguish, and others just wanted to help. They misidentified the wrong man. We got to get this right. It's not good enough the way that it is. I would sit in prison for 16 years and wonder why it was happening to me. I was an 18-year-old kid. Just a kid. Why me? I didn't understand. To me, it was obvious it wasn't me. I stand before you today basically begging you to participate in this, because there's some kid sitting somewhere now in a jail cell, and he's asking himself that same question. And I had the strength to not kill myself. I had the strength to not give up. I know guys in the joint that threw themselves off walks. I knew guys in the joint that stabbed themselves because they were giving up. I had the strength to not do that. But there's some kid tempted to do that right now. Are we going to defend him? Are we going to defend her? I certainly hope so. Now I can also, I remember an event that happened to me regarding interrogation while I was sitting over there. When I was in the county jail, the police approached my attorneys and they said, well, you know, we got nothing against him. They acknowledged it in a private meeting. We got nothing against Josh. So why don't we do this? Why don't we give him a lie detector test? If he passes the lie detector test, we'll let him go. We'll drop him. So naturally, my attorneys brought that to me, and I jumped. And I know I'm telling the truth. I know it wasn't me. So I jumped at the opportunity. They set it up. They transported me to a hotel. My lawyer said, do you want me to go in there with you? I said, no, I don't need you on this. I know I'm telling the truth. I had no idea. I was just a kid. I didn't know anything about science and technology and manipulation and things of that nature. I just went in on my own. And when I came out, I was confident. I was extremely confident. I'm going home. I even called my family. I said, man, I got to be coming home within days now, because they're going to see I didn't do this. I wasn't nervous. I wasn't nothing. They were asking me to think about crimes I didn't know anything about, and I can answer those confidently too, because I didn't know anything about those. But then they tried to come back and say I failed. Tried to use my lawyers to manipulate me into pleading guilty instead of going to the death sentence or life without parole. And again, thank God I'm stubborn, because I wasn't going to plead guilty. I knew I was innocent. Can't place that on every other person, though. Not everybody's built like me in that regard. The statistics say that. Not everybody's like that. Not everybody's going to have a conversation with their grandmother post-conviction and say, Grandma, Mama, I know you want me to come home. That's my grandma. I know you want me to come home. I know you don't want me to die in prison. I know you want me to get out before you die. I can't tell these people what they want to hear in a parole hearing, and I won't. I'm ready to die in here before I tell them what they want to hear. And they won't let a man out on parole. They won't give a man an opportunity for freedom post-conviction unless he tells them that he has remorse. And I feel bad for what happened. I have empathy for the lawless family. I would cry for them when I was on the inside. But how can I have remorse for something I didn't do? How can I express guilt for something? How can I betray myself like that? Put myself in that type of position. Other men do it. I have a friend of mine in JCCUC right now that did it. And right after he did it, he cried with me. Right before I got out, he said, John, I don't know what I just did, man. I said, I've been telling people I'm innocent for all these years, and I got so desperate I had to tell them something. See, we got people, these people are doing this because they're fighting for their lives. You can't expect people to make rational decisions of that nature. Well, they'll tell anybody anything. They'll do anything to get out. When they're fighting for their lives, they need us to fight for them. They need us to take up the charge. So they don't got to do that. So they can live with hopes and dreams and realize that hopefully 20 years down the road or 5 years down the road, can be standing in the exact same position I'm standing in right now, maybe even talking to you or talking to your predecessors or your people that follow you. just want to thank everybody for their attention.
I want to say I heard a man not dissimilar to Josh's story, a guy who was convicted of 2 rapes. He stayed in prison for 17 or 18 years, and during that period of time, it was just like Josh. He could have gotten out after 7 years, after 8 years, after 10 years, after 12 years. All he had to do was admit that he committed these 2 sexual assaults. He wouldn't do it. And what was heartbreaking to me about this story was an African-American guy. He had an alibi that the jury didn't believe. One of his alibi witnesses was his father, an African-American lawyer who testified at his trial, my son couldn't have committed the crime because he was home with me. And the jury found him guilty anyway. And it was only after 17 or 18 years DNA exonerated him, and he went home. Dad died in the jury. And that's one reason why I come to meetings like this, and that's one reason why we have to make improvements in our system.
I want to thank Josh. Thank you very much. Professors, both of you, thank you.